Hi, Matt. Welcome.
Thanks, Christine. It's nice to be here. Thanks for
Ah,
letting me be on
yeah.
here.
Thank you. We already got 15 people joining in. Wow, everyone wants to hear about estate planning. So thank you so much for joining. And then, yeah, so everyone, we have here estate planning attorney. He has so much knowledge about the estate plans, and that's like kind of very complicated topic. I've already had a lawyer before talk about this, but we can never talk too much about it. So different lawyers have different perspectives. So thank you so much for accepting the invitation to talk about it. So why don't you introduce yourself more so I don't, miss anything? I'll let you introduce yourself instead.
Sure, thanks.
Hmm.
Yeah, my name is Matt McClintock. I'm a practicing attorney, partner in a law firm called Evergreen Legacy Planning. Our main office is in Evergreen, Colorado, which is just up in the mountains a little bit west of Denver. We also have an office in Newport Beach, California. And our practice is limited exclusively to sophisticated estate planning mostly for affluent and ultra affluent families. That's kind of the niche that we found ourselves in. And just as a really quick bit of background, as far as that I think might be relevant, is that before I started this law firm in 2017, I spent the prior 10 years teaching estate planning law to other attorneys around the country. And so as a result, both my law partner and I have a lot of sophisticated expertise about the laws of a lot of different jurisdictions around the country. And so we kind of call ourselves a national practice that just happens to be located in Evergreen, Colorado.
Got it. Cool. So you can practice in which states?
I'm licensed and admitted to practice law in the state of Colorado, Wyoming, and Alaska. My law partner is licensed in the state of California.
Hmm.
And just for what it's worth, that's where I can physically practice law and represent clients. However, because I live and work in a jurisdiction where I'm admitted, I've got clients all around the country.
Hmm.
And I've got a lot of international clients as well. So it's kind of a tricky question as far as where we're licensed to practice, because really an attorney can practice law
Oh.
anywhere where the attorney is physically located and has an office, if the attorney is licensed to practice where they are. It really goes to
Mm-hmm.
where the attorney practices versus
Mm-hmm.
where their clients happen to be.
Got it. Good. Okay. So now let's get started on the fun topic of estate planning. So let's get started. Like, what is estate planning?
Um, you know, I like to look at it as a process by which you create a comprehensive plan for how you'll retain control over your assets and your own decision making throughout your lifetime, through any period of incapacity. If you get sick or get injured and you can't make
Mm-hmm.
decisions anymore, the estate plan creates a framework and identifies people to make decisions for you according to rules that you set forth. And when you pass away, it creates a really orderly and efficient and critically important private way for you to manage your affairs and ultimately pass what you've spent your life building to the people that you love most as tax efficiently as possible and in a way that helps them really become the very best version of themselves through a really
Mm-hmm.
carefully thought out series of
Got it.
strategies.
So I know you mentioned when we had our first chat, you said every grown up need an estate plan. So what is a grown up, and when does one really need to start thinking about an estate plan?
Yeah, I mean, I kind of had fun with that because, um, you know, estate planning it's one of those things that a lot of people don't like to think about because they don't like to think about their mortality. They don't want to spend the money for one. They don't often want to engage in a lot of the hard conversations around what happens when the world goes on without us. Um,
Mm-hmm.
but my point behind what I said when I told you that is that, I mean, that's just part of being an adult. I mean,
Yes,
it's
exactly.
we can't just pretend that
Yeah.
we're invincible and
Yeah.
invulnerable.
We're gonna
So
die
that's the
one
idea.
day, okay? So that's something guaranteed you're gonna die one day. That's why
Yeah,
like they.
and you can either control the situation, you can either
Mhm.
control the process, or you
Yeah.
can just let it happen. And
Hmm.
and a lot of people say, well, I'm dead. Why do I care? Well, if you
Yeah.
don't if
Yeah.
you think about that, yeah, you may not care, but you could leave a mess behind for the people that you really did care a whole lot about. And how do you
Yeah.
want to be remembered in future generations?
Yep, yep. So I'm gonna give two actual examples. Real life friends that actually, he was actually a realtor for this house. So he's actually our friend's dad. He just passed away on a vacation. They went in
Mm,
Mexico with, with his girlfriend at the time, and then he was swimming, and I don't know what happened in the middle of snorkeling. He just stopped breathing, and so he
mm,
passed away in the middle of the, like, over there, and then like people went there, he was just floating. So he passed away unexpectedly.
wow.
He was only in his late 40s or early 50s. He was fairly young. So, and then
Hmm.
he didn't even have a will or trust. So my friend actually had to, I think, like, they had to go to probate for some of the accounts. And
Sure.
then, so yeah, so it was a lengthy process. So like, why don't you explain to people, what if they don't have estate plan, what's gonna happen?
Yeah, it's a great question, Christine. And so the, I guess the good news and bad news is that whatever jurisdiction you happen to live in, whether it's here in the
Mhm.
United States, whatever state you're in, or if
Mhm.
you live internationally, whatever country you're in, or maybe even whatever province you happen to live in, it has a default system of rules that says that if I die and I don't have a will, I don't have a trust, I don't have anything, there are default rules that say who gets what and who
Mhm.
makes decisions on my behalf. Now, for your friend that you're talking about, you said that he has a girlfriend. Well, um, the girlfriend is not a legally recognized relationship, no matter
Yep.
how long they live together. So, a lot of jurisdictions would say, well, if they meet certain criteria, maybe she was his common law wife.
Mhm.
But if they don't represent themselves as such, then they're not a
Mhm.
married couple under any circumstance. And so, what is she entitled to?
Mhm.
If under the rules, nothing. She's entitled to nothing under the law. Not even if they had kids together, even if they have been together for 20 years, because they're not in a legally recognized relationship, she's not
Mhm.
entitled to anything unless
Mhm.
he has an estate plan that says, this is the person who's
Mm.
most important to me. This is what I
Got
want
it.
her to get. This is how it all works.
Mhm. Yeah, so it's either you have an estate plan or get married, right? So then you have the
Yeah,
legal rights.
yeah, but even if you do get married, the
Uh-huh.
laws of a lot of states, at least in the United States, say that okay, if you're married and if you have children, guess what your spouse
Mhm.
is entitled to? No more than half. Guess who gets the other
Mm.
half? Your kids. And
Mm.
so this now means that
Got it.
even though you might have said, hey, you know what, what's mine is hers, what's hers is mine, if you
Mhm.
don't if you don't have your property titled that way,
Mhm.
and if you don't have a plan that says that, that is not
Mhm.
going to happen.
Okay, so I did talk to one estate planning attorney before. I was asking her, it's like, when does one really need a trust or a will? So she basically told me
Hmm.
to put it, the simplest term is that if you have a dependent child or if you own a home, because then you can't just put like a beneficiary, like not like on your accounts. Like if you're very, let's say, on top of things and you always update your beneficiary, then maybe there might not need a trust or will. But if you have a house, you can't just go like, hey, beneficiary right there, right? It's gonna go to probate. So that's her simplest explanation. So, what do you think about that? Like, if do you have any add-on to that?
Yeah,
Yeah.
I'm not sure. I'm not sure I agree with that.
Okay.
I think that it's kind of hard to say. It's kind of hard to
Mhm.
put a bright line on
Mhm.
that. And here's what I mean by that. Because in order to understand at what point you need to go into some kind of estate planning engagement, it really requires a discussion around what problems are you trying to solve. If
Mhm.
you're only trying to solve the problem of avoiding probate, that's easy.
Mhm.
It's simply a matter of saying, well, even
Uh,
on a piece of real estate, if
mhm.
if you if you and I own a piece of property together as joint
Mhm.
tenants with right of survivorship, and
Okay.
I die, you
Yeah.
own that property.
Yeah.
That's as
Yep.
simple as that. I could do that with a kid. I could do that with anybody.
Mhm.
But in, if if then you end up getting sued for whatever reason, get in a
Mhm.
car wreck, business
Yeah.
failure,
Yeah.
divorce,
Yeah.
whatever, that property that you received
Mhm.
through inheritance
Mhm.
from me is
Mhm.
now in most jurisdictions subject to the claims of your creditors, and now you're going to lose. You have no protection over those assets. So if I solve the
Oh.
probate problem, I can solve
Mhm.
the probate problem with title to assets. Or
Mhm.
even in a lot of jurisdictions, including Colorado, you can actually have a beneficiary deed that says
Mhm.
that if Matt dies,
Oh.
Christine is the beneficiary who receives that. That can avoid probate. That's fine. But that doesn't
Oh.
solve the problem of protecting you from a
Okay.
future creditor if
Got
something goes
it.
sideways and you end up getting sued. So that's
Oh.
kind of why it's hard for me to say that, a certain level of assets, or if you have children or whatever. It's kind of
Mhm.
hard to
Mhm.
say. At least in my
Mhm.
perspective, the estate planning dialogue is a lot like the financial coaching
Mhm.
dialogue, which is,
Yep.
where do you want to go? What do you
Mhm.
want to happen? Because it's kind of like the story of the Cheshire Cat in Alice in the Looking Glass. Well, if you don't know where you're going, any road will take you there.
Yeah.
So we need to
No
know
matter how
where you want
crooked
to
that is.
go. Right. We want to know
Yeah.
where you want to go,
Yeah.
and then
That.
yeah, maybe you don't need an estate plan. Maybe you're fine with the
Mhm.
default rules, but make it an
Mhm.
intelligent decision, not just I'm
Yeah.
too lazy or
Yeah.
afraid to think about it.
Yeah. Or you don't want to spend the money either,
Right.
or
Yeah.
like you're like,
Right.
oh yeah, I'm gonna die anyway. Who cares? Yeah.
Right.
So you're
Totally get
saying
it.
that. Yeah. So you're saying that if everything like the house is in a trust, that you have protection against creditor. Then, like that's just the.
It
Go ahead.
lawyer answer. It depends. Um, so
Okay.
so
All right.
in most jurisdictions, if
Mhm.
I create a trust and I
Mhm.
put my assets in that trust, and then
Mhm.
I die, and you are the beneficiary of that trust,
Mhm.
you have very robust asset protection over the assets inside that trust, usually. Um,
Mhm.
and here's why. Because at that point, because I created the trust and now I'm dead, the trust
Mhm.
is irrevocable. Because I
Mm.
created the trust, you didn't have any control over how it was designed. Your
Mhm.
role is simply the
Mhm.
beneficiary, and maybe you're the
Mhm.
trustee as well. But
Mhm.
you didn't get to set the rules. You didn't put your own property in there. I set the rules and I put my property in there, and then I died and you became my beneficiary. At that
Mhm.
point, you have a lot of protection. Now,
Mm.
if I create a revocable trust for myself during my
Mhm.
lifetime, which I
Yep.
have done,
Yep.
um, and I put my house and my
Mm.
accounts and my vehicles inside that trust, I
Mhm.
have zero asset protection. Why? Because it's revocable by me.
Mm.
A
Got
court
it.
could issue an order saying, hey, divest the trust assets. You're the creator of the trust. You're the trustee of the trust. You're the beneficiary of the trust. The trust is revocable. You got no protection. Now,
Got
in
it.
some jurisdictions,
Mhm.
Wyoming is one of them, Alaska, South Dakota, Nevada, a whole bunch of them around the country and around the world. You do
Mhm.
have the ability to do some very advanced type of estate planning where you can create your own trust for
Mhm.
your own benefit and
Mhm.
get asset protection from it. But understand that is not the typical estate planning trust. That's a very advanced type of structure that we do for clients with
Mhm.
very high net worth with some discretionary assets.
Got it. Okay. Someone has a question. Sean Burks asks, how much does it cost to have an estate planning done? I know you're gonna say it depends.
How much?
So,
I was thinking about this question. I knew this question was coming, so I'll answer that question by asking, "What do you want? What's the problem you're trying to solve?" It's like saying, "How much is surgery?" Okay.
yeah,
I mean,
that's true.
if I'm having a mole removed, that's one thing. If I'm having a hip replacement done, that's something else. And
Yeah.
so it just there's so here are the variables. I'm not trying to
Mhm.
dodge the question. I can tell you what
Mhm.
I charge if
Mhm.
I'm think I probably can. But
Mhm.
it depends a lot on what what types of strategies you're implementing.
Mhm.
Sorry, I'm talking with
Mhm.
my hands. I'm getting a shadow. Apologize, but um, it depends on what types of solutions you're putting into place.
Mhm.
It depends how complicated or how detailed you want that to be. It depends
Mhm.
on what outcomes you're looking for. And a
Mhm.
lot of it, honestly, is driven by what market you happen to be in. So, for
Mhm.
example, a lot of really high population density areas, whether it's Los Angeles or Seattle or New York or whatever, a lot of really high density populations where you've got a lot of lawyers, they have a tendency to drive the cost down, um,
Mhm.
because you've got an awful lot of providers in a big market.
Mhm.
Now, there are also people who will sell you, whether it's what's the LegalZoom or Quicken Will or whatever. They're even attorneys, they're even law firms that will sell stuff online for a few $100.
Mhm.
Um, that's not my model, because I
Mhm.
don't see the estate plan as a commodity. I see the
Mhm.
estate plan as a relationship. I see an
Mhm.
estate plan as a comprehensive solution set.
Mhm.
And I don't know if it's appropriate to get into it here or if maybe it's part of a later conversation, but the way I look at estate planning is that there are different types of a family's wealth. There are different types of an
Mhm.
individual's wealth. There's certainly the quantifiable um,
Mhm.
type of wealth, and that's the one that's easy to see. That's the numbers on the
Mhm.
balance sheet.
Yeah.
And just transferring numbers on a balance sheet,
Mhm.
that's usually pretty straightforward. Even if the numbers are really, really big, there are proven strategies that can just move the numbers, save the taxes,
Mhm.
disinherit the IRS. But that's just one type of wealth.
Yeah.
There's human capital inside your
Mhm.
family. There's intellectual capital inside your family.
Mhm.
There is spiritual capital inside your family. There are the stories that you and your family are about. And the estate plan, at least the way we do estate planning, um, is we try to explore all these different types of a family's wealth and not just solve for the dollar
Mhm.
amount. We don't just solve to avoid probate, although we do.
Mhm.
We don't just solve to mitigate taxes, although we do. But
Mhm.
we look at how, Christine, you are building your career and you are working hard, you're making sacrifices, you're putting in a lot of hard work to build something.
Mhm.
Part of it's because it's fun, but part of it's because you want to build something of value.
Mhm.
And at some point in your life, what you spend your career building, the wealth that you accumulate over time, however vast or however modest that is, that will represent one measure of your life's work. That is worth imbuing with your values and making sure that then when it comes time, whether it passes to a parent, if that parent is disabled, making sure that they don't get disqualified if they have to qualify for needs-based assistance due to a disability. Whether you pass
Mhm.
it to a kid, making sure that kid's not just gonna, even if they just inherit $100,000, do you want to dump
Mhm.
$100,000 in the lap of a kid who's 21 years old?
Yeah.
Probably not. You know,
That's
so
when you need. Mhm.
so the idea of trying to give you a dollar amount on what an estate plan costs, it's an impossible question for me to answer. I know everybody wants to know. Um, I
Yeah.
think probably more than that. But before you start thinking about how much it's going to cost, I think it's worth learning about what the process should look like and what the
Mhm.
possibilities are, and then make a decision based off of what your budget says.
Mhm.
And your budget may only be a $200 will or whatever right now, but
Mhm.
this gets to something else, Christine, I know we're going to talk about, and I don't
Mhm.
want to steal your thunder, but it's this idea of estate planning being an iterative process. The estate
Yep.
plan you have today is not the estate plan you need 5 years from now, or 10 years from now, or 20 years from now.
Exactly. So I guess like when people hire you, like is it normally at the retainer value? Like when they come to you, they share you the information, how their situation is. So do you kind of quote them already how much it is, and then that's already to finish this estate plan, and then yearly or whatever, however often they need to come back, then they just pay whatever retainer fee after that.
That's typically how I do it. So what I
Okay.
do is I'll usually do a discovery call with somebody.
Mm-hmm.
That can be as short as a half hour. Sometimes it can be an hour to an hour and a half, just kind of depending on what
Mm-hmm.
issues they want to get into.
Mm-hmm.
We kind of do a little bit of rough pre-qualifying just to make sure that they're a good fit for our firm. But then I'll sit down with them. Right now, because of the pandemic, we just do everything
Yeah.
virtually. We
Yep.
do video conferencing all the time. But then
Yeah.
we just kind of do a discovery and we say, look, this is, I kind of learn about them. I learn about what problems they're trying to solve, what challenges they're facing. And
Mm-hmm.
then, depending on the outcomes of that conversation, probably 9 times out of 10, I say, okay, well, here's what I will
Mm-hmm.
recommend. And I'll walk you through that. And at the end of that conversation, I will give you a fixed dollar amount. I will tell you
Mm-hmm.
exactly how much it's going to cost you to solve
Okay.
this problem. But first, I've got to know what problems we're solving.
Yep.
And that could range
Got it.
anywhere from a few hundred, that can range
Mm-hmm.
anywhere from a
Mm-hmm.
few $1,000s to tens of thousands of dollars or more, depending
Mm-hmm.
on the scope of work. And
Got
so,
it.
usually I can start to figure out if it's going to be just kind of a clean engagement. This way, okay, we're going to do a foundational revocable living trust centered plan, and
Mm-hmm.
here's what that looks like. Here's what's included, and here's the price.
Mm-hmm.
Or I've got to dig in through a whole lot of existing documents, and then you're going to retain me just to do an analysis
Got it.
And then, so then once we've got the body of work, we establish a body of work, usually in an initial consultation that doesn't cost anything but time.
Mhm.
And then we'll have a fixed body of work that says, okay, for us to do this, it costs X. And
Mhm.
then we simply set the expectation to say, look, what you're paying for is this body of work plus a couple of additional hours of
Mhm.
getting you up to speed, transferring
Mhm.
assets and that kind of stuff. And
Yep.
then, you're kind of on your own unless you want to just, we'll drip on you about once a year, no charge,
Mhm.
no obligation, nothing like that.
Yeah.
But if you green light from additional work, then we'll create a new fixed fee. And the reason I do that, I mean, I don't like doing hourly work anyway, because
Mhm. Yeah.
I know it's a lot of attorneys still work by the billable hour. I just think that it rewards inefficiency, and
Yeah.
it interferes with free and open communication.
Yeah.
So I want my clients to feel like they can pick up the phone and call me. They
Got it.
can,
Yep.
they can ask me a question, and they don't have to worry about, is this a $5 question or is this a $500 question?
I
It's like,
yes, I know what
so
you mean.
I want to be on the same side of the table as the client.
Got it. Got it. Okay. So let's say the person doesn't own a home, whatever, and then they're always on top of their their whatever. Let's say they only have a retirement investment account. They don't have kids. So what if they're always on top of just updating the beneficiary? Are they okay not having any trust or will done or estate planning?
How do they want that beneficiary to receive that money?
They don't have any kids.
Who's their beneficiary?
I guess nobody. Maybe a charity then.
Well, if it's a charity, great.
Oh, no,
If
no,
it's
no. Wait. The beneficiary will be you're right. So the beneficiary will be maybe a family member, any family member that's younger, whatever. So they just have to know, okay, they're the beneficiary. So if it's the I pass away, if I pass away, then they have to know, okay, then they can claim that. So
Mhm.
is there still a need for a trust, assuming everybody knows what's happening, and they're very always up to date on their beneficiary.
So a couple of questions I would ask in response.
Mhm.
One, do they care how quickly that account gets liquidated after death? Because if they do,
Mhm.
then simply dumping it out in the lap of a kid isn't going to solve any problems.
Let's say
Because,
they're an adult. Let's say they're an
okay,
adult.
so
Mhm.
if it's an adult,
Mhm.
then the adult is going to be able to stretch it out for a period of 10 years. Is that right? I can't remember the new Secure Act rules now. But so the rules changed at the end of December of last year as far as how long you can stretch. But you're going to lose deferral of income tax if you don't have some kind of wrapper around
Ah.
the account.
Oh,
And
okay.
so what if let's say it's going to your sibling, you got a
Mhm.
brother or sister,
Yep. Yep.
whatever.
Mhm.
Um, so then you say, okay, well, that's great. You know, what if that sibling gets sued? Okay,
Mhm.
well, the inherited retirement account is
Mhm.
not protected from bankruptcy or any other kind of proceedings in most jurisdictions. There's about 7 states in the
Mhm.
United States that
Mhm.
protect an inherited account.
Mhm.
Very few of them do. So if the
Okay.
beneficiary gets sued or files
Mhm.
bankruptcy,
Yeah.
that inherited account is now an asset of the bankruptcy
Mhm.
trustee, which
Mhm.
then turns around and liquidates the account. Guess what? Recognizing all the income tax that had been deferred at that point. So
Mhm.
now you liquidate the account and generate an income tax liability that the beneficiary is now stuck with that doesn't get discharged in bankruptcy. So that's one issue. What if
Mhm.
your brother is now the beneficiary of this retirement account and he's had a stroke or he's been in a wreck? And now let's say we've
Mhm.
got $250,000 in an inherited IRA. Well, that inherited
Mhm.
IRA will have to be spent down, accelerating
Mhm.
income tax all the way
Yeah.
before your brother can then qualify for needs-based assistance due to his disability.
Mhm.
So it's, again, the thing is, Christine, this gets back to the question
Mhm.
of what problem are we trying to solve? If we're just trying to solve the problem of who gets my stuff, you don't need an
Mhm.
estate plan for that. You need
Got it.
beneficiary
Got it. Yep.
designations for that.
Yep.
But if
Got
you're
it. Got it.
but if you think more about what
Mhm.
does, you know, that retirement account came at a cost to you, the
Yep.
investor.
Yep.
You
Got
went
it.
without, you you set money
Mhm.
aside. Why? If you set the
Mhm.
money aside only to see it get accelerated down to pay income tax and then go satisfy creditors, that's a really stupid way to manage your money.
Yeah, yeah. Or you
See what I'm
make sure you
saying?
spend your money before you die, but
Right.
then no, we
Yeah,
cannot plan
that's
for
it. I
that,
mean,
right?
if you can spend your last dime when you exhale for the last time, then you win. You
Oh,
win.
here's my $100,000 check. Here you go before I die.
You know, you could be like the Joker in the Batman movie and just burn it all, you know? But most people don't want to do
Yeah,
that.
yeah,
Most
yeah.
my
All right.
my
So
clients don't generally want to do that.
yes, so trust is really just so you can have specific instructions. So remember that it's for specific instructions, so you have control over it. So that to just a
Right.
simple answer of like who it will get to, then you might not need it, right? Then you're like, ah, I don't care. Then go to my brother. He can do whatever he wants. Then maybe you don't need the
Yeah.
trust, right?
Yeah, and
Yeah.
to be perfectly clear,
Mhm.
a will can do that too. So
Mhm.
you don't have to have a trust in order to
Mhm.
have those really detailed instructions. Um,
Mhm.
I prefer trusts because they privatize the process.
Yes,
If you
they do.
have a will, you're still going to go through probate of some sort.
Mm.
It may be an abbreviated probate, it may be what's often referred to as an informal probate, but you're still going to go through some kind of court proceeding. So it's wills are usually less expensive to put into motion for people
Mhm.
simply because you don't go
Mhm.
through the process of retitling assets
Mhm.
like you do
Yep.
with a trust. But
Yep.
you can have just as many details inside your will as you have
Mhm.
inside your trust. But just
Mhm.
understand that the idea of going will or trust should be
Mhm.
driven mostly by, do I want to privatize this process, or am I
Mhm.
content to go through the courts to
Mhm.
publicly administer the process?
Got it. So now that brings to the question: what's the difference between wills and trust? Is that all trust must have wills? Like, is the will the instruction for a trust, and then wills come and with or without a trust? So.
So a will, so the way I look at it is every estate plan has a centerpiece,
Mhm.
and the if the will is the center, so both wills and trusts
Mhm.
are designed to distribute your stuff, your property. Doesn't do anything about
Mhm.
medical decisions,
Yep.
but a will and a trust is a device for transferring property ultimately
Mhm.
from a dead person to a living person. That's what it does.
Mhm.
Now, if you have a will, the
Mhm.
will does you nothing during your lifetime. It doesn't provide the appointment of a trustee or somebody to make financial decisions if you're
Mhm.
alive but
Mhm.
incapacitated. The
Okay.
will doesn't work yet because
Yep.
the will only works when you're dead. The
Got it.
trust, on the other hand, creates a framework where you can appoint your own decision makers to
Mhm.
manage the trust's property if
Got it.
you are alive but incapacitated. The trust
Mhm.
also works after death. But again,
Mhm.
within the trust, you, as the creator of the trust, get to designate who those decision makers are, and you don't have to have a court authorize them to do that. Within
Mhm.
the will, you have to name an executor or personal representative, and they can't do anything until they get a court order that says you are hereby formally appointed the executor of Christine's estate.
Mhm.
So the wills might create a trust inside of it. That's
Mhm.
called a testamentary trust, a
Mhm.
trust that establishes after death.
Mhm.
Um, and then a will, what if the will is the centerpiece of the estate plan? It should also have powers of attorney, durable powers of attorney for property, to manage your property in the event you become incapacitated,
Mhm.
medical durable powers of attorney to appoint somebody to make medical decisions for you if you're incapacitated. Now, a trust centered estate plan, if the trust is a centerpiece, then the trust will also have those durable powers of attorney for property and for healthcare. But a trust centered estate plan has a very specific type of will called the
Mhm.
pour over will. What that does is it kind of acts as a property safety net that
Mhm.
says that if I died and I
Mhm.
didn't have some of the assets inside my trust, because
Mhm.
the issue is, what if you have the trust, you want to put your assets in the trust. But if you
Mhm.
die and somebody says, oh wait, Christine had this condo or this vehicle or this account that was in her individual name, what that pour over will does is it still has to go through probate like any other will does. But
Mhm.
it says that through the end of that probate process, we're not distributing that property to my heirs. We're distributing that property to my trust. It pours it over into the trust.
Mhm.
And now the trust becomes that privatized environment through
Mhm.
which we can manage the deceased person's property.
Got it. Got it. So I know this is what I was studying for my enrolled agent. They always use this example about Michael Jackson. Like,
Mhm.
remember he had, I think he had a will, right? But he doesn't have a trust. And I think, I
Mhm.
don't know, it's finalized now with the IRS. I don't think so, right? It's like it's been over 10
I'd be
years now.
surprised. I'd
Yeah.
be surprised. It's a massive estate.
Yeah, so if everyone doesn't know, like Michael Jackson didn't have will, and I think most of the celebrities, they don't even
A lot
yeah,
of
I
them
mean,
don't
I
because
know, it's
they're
like
invincible.
I'm like,
They're immortal.
hello,
They're
yeah,
they're invincible until they're not.
yeah, like in the movies, like, how they're all immortal in the movies, right? So it happens in real life too. So yeah, so you'll be surprised. Like some of them don't even have a will. I think, at least Michael Jackson had a will, but see, like, now, like, they still have that issue. Like IRS is trying
Yeah.
to, like, say, oh, Michael Jackson's worth really a lot, and then his
Mhm.
attorneys are saying he's not worth a lot because of what
Right.
happened to him during the later stages. So they're fighting against the word. The IRS, of course, wants so they can tax a lot, and then this one not tax. So it's like if he had a trust, then that would. I mean, what do you think? It would have solved all that problems that they're encountering
No, no, it would not have
now.
solved that problem. I mean,
Mhm.
that problem is solved by valuation issues, and they're
Mhm.
arguing over what his royalties are worth and what his properties
Mhm.
are worth or whatever. And
Mhm.
there are advanced estate planning techniques you can put into motion that will
Mhm.
drive those values down for tax purposes.
Oh.
I've been working on one of those today, as a matter of fact.
Oh. Cool.
But the the issues that most celebrities' estates kind of get into. It was Philip Seymour Hoffman was another one, and Aretha Franklin and Prince. Um, they famously did not have, I think Robin Williams as well, kind of did not have very comprehensive estate plans. What usually
Mhm.
ends up causing problems is not around the valuation issues with the IRS. It's
Mhm.
usually around who gets what. And, you know, in for whatever it's worth, a lot of these celebrities have relationships with other people and end up having children with other people.
Yep.
And then what are they entitled to? And
Yeah.
business deals that went sideways, and what are those creditors entitled to? And what rights did they retain, and whatever. So those do get highly complicated. Some of those issues, certainly not all of them, but some of those issues can be avoided with really carefully thought through and well executed estate plans. But the other side of it is those stories are kind of fun and interesting because we all know these celebrities and we all kind of
Yeah.
sometimes aspire to have those types
Yeah.
of problems. Um, but I mean, the reality is um, we're all going to see someday where
Mhm.
we're not around anymore, and
Yeah.
we know. I'm not sure what data you're seeing, but what I've seen is you are. We have like a 50%, maybe higher likelihood that we're going to spend some period of being disabled before we actually die. How do we
Mhm.
make sure that the decision makers we know and
Mhm.
trust especially the decision makers we want, are the ones that will
Mhm.
actually be empowered? If we don't
Yeah.
have a really clearly thought out estate plan, we could have an
Mhm.
abusive child. This is where a
Mhm.
lot of elder abuse comes in, is where somebody
Yeah.
gets empowered because they filed a court action to now manage mom and dad's property. And before long, we
Yeah.
see a lot of elder abuse kick in. But if we plan in advance and we keep that plan up to date, then
Mm.
we reduce the likelihood. We can't eliminate it, but we can reduce the likelihood that some of those abuse things will actually take place.
Mhm. Yeah. Ruben Ortega just joined. He said, "Hey, Christine and Matt. Sorry I missed earlier just joining in, but what is the difference between will and trust and administrator versus executor?" So, Ruben, we just talked about the will and trust, so you can just listen back to the replay. I'm actually gonna convert this to the podcast so you can listen to that as well. So, why don't we talk about what is the difference between administrator versus executor?
Yeah, it's kind of a distinction without much of a difference.
Mm-hmm.
So at least in the probate context, this is what Ruben may be asking about. An administrator is usually the person who is appointed by the court to manage the estate of someone who is intestate, which means they died without a will. It's
Mm-hmm.
usually referred to as the administrator. Now, an executor, in some jurisdictions, use the term personal representative, but the
Mm-hmm.
executor is the person named in the will. And then the
Mm-hmm.
executor, if you have a will that names Christine as my executor, Christine then takes the will to the probate court in the jurisdiction where I died. And she
Mm-hmm.
said, here's Matt's will. He names me as the executor. The court says, okay, this looks like a valid will. Christine, are you
Mm-hmm.
willing to execute this to the best of your ability and according to the laws of whatever jurisdiction? You say, yes, Your Honor. And then you
Mhm.
are now appointed by the court as my executor, but it's because I named you. If
Mhm.
if I don't have that will, if I am
Mhm.
intestate, then if you any party in interest, anybody who says, hey, I think I'm entitled to something from Matt's estate,
Mhm. Mhm.
whether I'm a creditor or whether
Mhm.
I'm an heir, then I can say, okay, hey, judge, Matt died. He has some stuff. He doesn't have a will. I want to be appointed as the administrator to then
Mhm.
manage this stuff.
Mhm. Yeah, got it. Okay, Ruben, I hope that answered your question. Okay, so what about, okay, so we talk about, how estate planning, you have to keep like update because life change, you have to update that. Just like working out, right? Like if you stop working out, then of course you're gonna either get fat or whatever if you still keep eating a lot. So yeah, how is estate planning like financial planning or working out where you have to regularly update that?
I mean, it's kind of my point. I mean, it's
Mhm.
iterative. It's like saying,
Yep.
well, I brush my teeth.
You just
It's
do
like
it once. That's it. That's
just
it. You
once.
don't have to
Yeah.
brush.
No, it's it's not quite that bad. That's
Just
admittedly an
kidding.
oversimplification. But the point is, the reason I kind of talk about it in those terms of it being an iterative process
Mhm.
is that I mean, another way to look at it is that the estate plan you signed today is basically a snapshot of this moment in time.
So,
We're looking at your assets today. We're looking at
mhm.
your family today, your priorities,
Mhm.
the law, the opportunities today. All of that's going to change. Every part of it's going to change. The
Yep.
economy is going to change. The
Mhm.
laws are going to change. Your
Mhm.
objectives are going to change.
Yep.
Your assets are going to change. Everything is going to change. So that
Mhm.
doesn't mean you have to redo your estate plan every couple of months. That's not what I'm talking about.
Yep.
But you should have a running dialogue with your estate planning attorney to
Mhm.
say, hey, you know what? I was kind of thinking the other day that the person that I named as my executor under my will or the agent under my power of attorney, I've kind of lost contact with them or passed away or whatever. Those need to be updated from time to time.
Yep.
And again, the law is constantly evolving. We are expecting a new tax code, within the next couple of years at the latest, because
Mhm.
you look at what the economy is doing and the unlimited quantitative easing, and we know that the federal estate tax law already has a built-in expiration date. We
Mhm.
know that that will end at the end of 2025. And
Yep.
no later than that, we'll get a new law. But a lot of us inside the industry are thinking it's looking more likely than not
Mhm.
that we could have significant tax changes even as early as next year. That's
Mhm.
going to change a lot of people's estate plans because people who don't
Mhm.
have an estate tax problem right now, they might in
Mhm.
2021. Um,
Mhm.
the laws of the jurisdictions are constantly shifting. My adopted home state of Colorado enacted an entirely new trust code that
Mhm.
went into effect January 1 of 2019.
Mhm.
So that means all the estate plans, will-based estate plans or trust-based estate plans in Colorado had better get at least reviewed and potentially significantly revised because there's an entirely new body of law. Um,
Mhm.
Uniform digital access to assets laws change.
Mhm.
If I'm your executor, and now I need to come in and shut down, kind of wrap up your LinkedIn profile. How do I have authorization to do that? If your estate plan doesn't give me authorization to do that, guess what? I'm committing federal felonies that go into anti-hacking laws.
Mhm.
So, our social media stuff needs to be contemplated in our estate plan. Our crypto assets have to be contemplated in our estate plan. I mean,
Mhm.
there are new issues that arise all the time that
Yep.
estate planning, just like financial planning, has to account
Mhm.
for.
Yep, exactly. So do you also like if a client come to you, they're super wealthy and stuff like that. So I guess do you help them with like tax planning aspect of it too, like multi-generation
Oh
wealth?
yeah,
So that's kind of okay. So okay, so awesome. So yeah, because I actually recently had a client. We'll just talk offline about that, but they're also very wealthy, and then they're looking for someone who can help with that one as well. Okay, so
that's really our sweet spot, quite honestly. I mean, the vast majority of our
mhm,
clients are have federally taxable estates under this current environment. So the vast
mhm,
majority of our clients are well north of the $20 million range.
mhm. Got it. Okay. So, okay, why are some estate plans created in different states? Are you saying different estate plans for different states? Is Oh,
hmm
okay.
Yeah. So I was kind of alluding to this when I was talking about some of
Mm-hmm.
the just some of the inheritance laws. But
Mm-hmm.
so remind me, what state are you in?
I live in California.
Yeah, that's what I was afraid of. California's terrible. I mean, I love
In terms
California,
of what? In
but
terms of what?
they're well, in terms of inheritance laws for one, in terms of their
Why?
income tax
Why?
laws
Tell
for
me. Tell
another.
me why.
Yeah, yeah. So the ability for you to create an asset protection trust for yourself is very, very limited. Your income taxes are draconian, and so, uh, but we
Uh-huh.
can we can create plans for people in California or in
Okay.
Oregon or in a lot of other jurisdictions that have high
Mm-hmm.
income taxes, high state
Uh-huh.
income taxes, or that
Mm-hmm.
have weak trust laws.
Mm-hmm.
And we can then take those clients and put them in various strategies in other jurisdictions that have zero income tax from a state perspective,
Mm-hmm.
and that have very robust asset protection laws for what's called a self-settled or self-created trust.
Mm-hmm.
So
Mm-hmm.
Colorado is not a great jurisdiction either for trust. I was kind of
Mm-hmm.
poking at you a little bit, but I mean, California's trust laws aren't very good. Neither are Colorado's. But you know who's are really really good? South
Which?
Dakota. South
Okay.
Dakota. Wyoming is pretty
Okay.
good. Nevada's really good. Tennessee,
I'm moving to
Ohio.
Nevada soon.
There you go. Well, that's a smart move for lots of reasons.
Yes.
But
Mm-hmm.
um, the there are some jurisdictions in the United States that have made it a legislative priority to make themselves attractive for trust related business. And so
Mm-hmm.
those are some of the states that I've mentioned. And really some of the most important ones are Nevada, as you've already zeroed in on,
Mm-hmm. Mm-hmm.
South Dakota by a long shot, Wyoming's quite good,
Mm-hmm.
Delaware also quite good.
Mm-hmm.
And so where a lot of our expertise comes in is in knowing the laws of these other jurisdictions and why maybe
Mm-hmm.
Nevada makes sense for you, or maybe South
Mm-hmm.
Dakota makes sense for you, or maybe Wyoming or whatever. And it really depends on what you want your plan to accomplish.
Mm-hmm.
And then because we can put you in a protective zero tax environment, there are
Mm-hmm.
a lot of options for that. But depending on what you want to do, South Dakota might make more sense than Nevada, or Wyoming or whatever. So now you can't take all of your assets necessarily and put them in one of those types of jurisdictions because you can't render yourself insolvent for creditor purposes. However, uh, if we work well in advance, there are ways that we can start to build some protection around kind of rainy day assets, we might call them, or a business interest or whatever. And for a lot of clients, even for a lot of California clients especially, we're doing a lot of Wyoming or South Dakota based irrevocable trust planning, and then allowing, kind of helping them liquidate liquidate assets through one of these other trust structures in a way that dramatically reduces the impact of California state level income tax. So
Mm-hmm.
that's a big part of what our practice is all about, is
Mm-hmm.
kind of pairing up the right jurisdiction with
Mm-hmm.
whatever problem it is the client is trying to solve.
Got it. So oh, I'm a little confused. So what if they live in California? You're saying they can create a
hmm
trust in Nevada or South Dakota?
Yeah, do it all the time.
Oh, but how does that work? I guess the trust is not based on where you live then? Like you can, like what if you have a house in
It depends
California?
on the kind of trust. Well, if you have a house, if you're talking
Okay.
about real estate, that becomes really tough because real estate is physically located in California.
Yes.
But let's say it's a business, or let's say it's Bitcoin.
Okay.
We're doing this right now. We've
Okay.
been working on this for a really large Bitcoin client in
Mhm.
California,
Mhm.
um, and so Bitcoin is not even tangible. It just exists
Yeah.
on a blockchain, and that's a
Got it.
whole other conversation for their time. But this client at today's valuation has about $113 million worth of Bitcoin. She's a
Mm,
California
wow.
resident. Her basis
Okay.
is zero on that Bitcoin. So if she were to liquidate that, she's going to pay 13.3%
Yep.
of 11 million bucks. No, excuse me, of
That-
111 million bucks.
yeah,
So
that's a lot.
now we're talking about $20 million worth of tax
Yeah.
liability just right
Yeah.
there. What we have done is, because So we didn't do this with her house. We didn't do this with her bank accounts, but we did this with her Bitcoin because it's a commodity. It's just like
Okay.
a equity portfolio or whatever.
Yeah, yeah, yeah.
We created a couple of different irrevocable trusts in Wyoming because
Okay.
Wyoming is a zero tax jurisdiction, very protective trust laws, and really
Mm-hmm.
comprehensive cryptocurrency laws as well.
Mm-hmm.
We then helped her set up custody with
Mm-hmm.
a crypto custodian, and we had
Mm-hmm.
to design the trust in a way where we sever her control. So once she
Mm-hmm.
transfers it in, she can't reach in and grab it back.
Yep.
But she is the beneficiary. She's one of the beneficiaries of this trust. So now, when we help her sell Bitcoin through this trust, it gets sold not as a California resident, it gets sold as a Wyoming resident because of the type of trust it is. It's an irrevocable
Oh,
trust.
got
It's an
it.
irrevocable trust that she created, and by the design of the trust, it becomes a
Mm-hmm.
separate taxpayer for federal income tax purposes. So
Mm-hmm.
then, when future sales take place, those sales take place through a Wyoming structure, not through a California structure.
Mm-hmm.
Now,
Got it. Wow.
some jurisdictions have put the kibosh on that. You cannot do that for people in New York, for example.
Ah,
Um,
yes, New York, right? They always have very
yeah,
strict rules there.
they're just really savvy about their tax revenue.
Who's worse, New York or California?
Well, if you live in the city of New York City, it's worse.
Oh,
If you
yeah,
live
yeah.
if you live outside of the five boroughs area, California is worse.
Yeah, so you're saying okay, so you can do this with Bitcoin. Can you do this with other investments account,
Yeah. Oh
brokerages
yeah.
or retirement?
Yep.
Also, the
Small
only
businesses.
exclusion okay, the only exclusion is just your property.
Now there are more exclusions than that, but that's a
Okay.
really easy one to identify. And it's because how do you take a
Okay.
piece of real estate that occupies it's physically occupied
Exactly.
in
Exactly.
California? How do you
Yeah.
take that? I mean, there are
Exactly.
some strategies that are pretty aggressive that I've seen people
Yeah.
try. Um,
Yeah.
I don't
Got
really
it.
want to talk about that on the air because California may just get wise about it.
Yeah, so okay, so basically the other stuff that's not physically here, then you can technically sell under whatever irrevocable trust you set up in whatever state you set up. Wow,
It's
that's
possible.
awesome.
It is possible. It's
Got it,
hard.
got it.
It's complicated, but it's possible.
Yeah. Got it. I love it. I love it. I learned that's a big thing I learned today. Okay. So and it's I guess it works the same thing with businesses, right? Like when they set up
Yeah.
LLC, whatever, they do it in a very business friendly state so they
Yeah.
don't have
Right.
yeah. Like for
For
example,
sure.
let's say California, right? Like California, the LLC is expensive. It's like $800 a year. So can they set up
Mhm.
an LLC in another state like Nevada, but still practice in California?
They can, but the franchise tax board is still going to get them because now you've got. And here's why: because you still have
Hmm.
to register that. Let's say you got this. So it's now a foreign entity. It's a Nevada LLC. But if you're doing
Hmm.
business in California, you're going to have to register that LLC in California. So the FTB is
Hmm.
still going to get you on their fees.
Got it. Got
So
it.
that's one of the things
Yeah.
that the FTB is really good at. So FTB is the Franchise Tax Board,
Well, what if it's all
basically the
remote
IRS of
now?
California. Yeah,
Well, it's
yeah.
remote now with
So if you
COVID. Yeah,
but if you're physically located in California doing what
that's
you're
right. Yeah,
doing,
yeah,
they're going to say, well, you're really doing business in California. You don't have to have a brick and mortar. You're here in
yeah,
California. We want our share of the revenue. That's just
yeah.
the way it works.
Yeah. New York is also very tricky. Like if you have a New York, your company's in New York, but let's say you're in Nevada with no state income
Hmm.
tax. But if you're remotely working for New York company,
Yeah.
they will
Yep.
still tax you. But
It's called
not
forced income.
exactly.
Yep.
But then not all state does that. If you're remotely working in
Right.
other places, but other
Right.
most states don't tax you if you're doing remote, even if the company's there. But New York does. So I was like,
Yeah.
wow, okay,
And
yeah, New York.
that's really why it's critically important that your
Mhm.
viewers and listeners talk to really good accounting professionals as well, whether they're
Exactly.
enrolled agents, CPAs,
Hmm.
whatever. They really need to be getting a lot of really proactive tax accounting advice to make sure that they don't end up making what's called nexus or that legal tax connection to
Exactly.
a jurisdiction that they don't really intend.
Yes. Hmm. Yeah, and then like I actually worked for TurboTax this past season, and all I can say is that I think most people shouldn't be doing their own taxes. So there's no offense, but I
I
think
don't do
you
my own taxes.
I think you should just hire a financial professional because yeah, my
one Hundred
experience that
percent.
they call in and most people can't even read instructions like which is
Yeah.
literally right there. So it's like please just go somewhere else and then do it unless you're fairly good at DIYing. And I think most people shouldn't even be doing their taxes.
No,
So
but most people
anyways.
are terrible at that. And honestly, I don't do my own dentistry. I don't do my own.
Yes. Yeah.
I don't do my own
Yeah.
taxes. I do
Yeah.
my own legal work, but it's because I'm a lawyer and I'm admitted to practice in a handful of states. People
Yeah.
should not be doing their own estate plans. People should probably not be doing their own taxes. They certainly should not be doing their own dentistry. So it's, there are, I understand people don't want to spend money that they don't have to spend. And I understand that people are concerned about making sure that they get what they pay
Yeah.
for.
Yeah.
But the other side of it is you do have a tendency to get what you pay for.
Yeah.
And so it's,
Mm-hmm.
people shouldn't overspend, but I
Mm-hmm.
think that I think that worse than overspending is actually underspending, because if you spend anything and you get something that doesn't really do what you want to do, guess what? You've
Mm-hmm.
wasted that money. One
Exactly.
dollar of every dollar you spent is wasted. Versus,
Exactly.
hey, you know what? I spent maybe more than I should have, but I got a really, really good plan. Well,
Mm-hmm.
maybe you didn't get a bargain in your mind, but
Mm-hmm.
it's still money well spent. Versus, might as well just you know do like
Yeah.
the Joker and light my money on fire.
Exactly. So Tanya has a good, something to say. So as a funeral director, so many folks with POA do not understand that POA passes when a person passes, and then the interim process of executor in certain cases, I would see this time and time again with the signing of funeral home documents.
Oh gosh, yeah, absolutely. That's absolutely right. Um, so one critical thing about POA, powers of appointment, or
Mm-hmm.
powers of attorney rather, powers of
Mm-hmm.
attorney. I've been working on a tax thing. It's powers of appointment, but powers of attorney. Um, what that means is a power of attorney is a document that says I hereby appoint and designate somebody else to make legal decisions for me. If it's a
Mm-hmm.
property power, then they're making property decisions. If it's a medical
Mm-hmm.
power, they're making medical decisions. So that's
Mm-hmm.
a power of attorney. Now,
Mm-hmm.
every jurisdiction also has an option to create a durable power of attorney. And that simply means that if I become incapacitated,
Mm-hmm.
the power of an attorney still operates. It still functions.
Mm-hmm.
It's durable in that it withstands my disability or my incapacity. It does
Mm-hmm.
not withstand my death. If I die, the power of attorney dies with me.
Mm-hmm.
Now we have to look at the trust. If there's a trust in place, who's that successor trustee?
Mm-hmm.
Or if we have a will, who is the executor? But remember what I said, the executor doesn't have any legally binding authority until the court appoints them.
Yep.
Okay?
Got it.
So nobody is going to sign that funeral director's contract in a legally binding way until they have what are called letters testamentary or letters of administration appointing the executor or administrator of the probate estate,
Mm-hmm.
or the successor trustee of the trust who can now legally bind the decedent's estate or the decedent's trust
Mm-hmm.
to the terms of the contract that the funeral director
Mm-hmm.
has.
Yep, yep, guys. So yeah, there's a lot more at stake here, guys. So it's like I think just consider it, and then estate planning is a huge topic. You can never learn too much about it. I actually have an attorney coming into, like, I just don't think this is just like such a huge topic. And I also have someone else coming in, like they offer that, like you said, I forgot what his company name, but he's gonna come and talk to me. But then it's like legal Zoom type of thing. So
Mm-hmm,
we're just
mm-hmm.
gonna talk about what they offer as well. So in
Sure.
case anyone's interested in that as well. So okay, so thank you so much, Matt. This is so enlightening. I learned so much, and then I'll be converting this to podcast so people can listen easily. So how can people find you, and then people want to get in touch with you or whatever? Hmm.
Yeah, the best, one of the easiest ways is through LinkedIn. If you do connect with me through LinkedIn, connect me through Christine, just so I can make that connection in my mind that, hey, you listen to this broadcast, and I'm a friend of Christine's. So peg me there. You can also
Hmm.
just find us on the web at www.evergreenlegacyplanning.com.
Hmm. Hmm.
That's where you can learn a little bit more about our firm, who I am, what we do. That's the easiest way.
Got it. Got it. Okay, great. Thank you so much, Matt. And then thank you everyone for listening. I hope you got a lot out of this, and have a great night, everyone. Thank you.
Thanks
Bye
a lot,
bye, Matt.
Christine.
Okay.